appeal back to the matter of Cobalt Data Centre LLP and Commissioners for His Majesty's Revenue.
Before we resume, Mr. Williamson and Mr. Ewart, there are two matters for me to raise. The first is that our need to rise early today has gone away, so we can carry on till 4:15. The second is that we received an application yesterday from Pinsent Masons, who are acting for clients who are involved, they tell us, in similar disputes with HMRC. The application is made under the CPR for disclosure of the skeleton arguments filed by both parties in connection with these appeals. We have discussed the application amongst ourselves. We routinely make skeleton arguments available to law reporters, and we can't at the moment see any particular reason why they shouldn't be made available. We have been asked to make an order to that effect, but it may be that the parties don't need an order and that they would agree to provide Pinsent Masons with their skeleton arguments.
We'll take instructions.
Yes. I mean, if there are real objections to doing it, then of course we'll hear the objection.
I can't imagine what they might be. I ought to take instructions.
Yeah.
My Lords and my lady, can I mention a matter of housekeeping as well, which is that the members of the court physically present should have received a slim file about 10 minutes ago.
Right.
And Lord Justice Newey, I'm afraid, should have received the same by email.
Oh, that's got the 7 cables case in it, yeah.
So what this is the Australian case your Lordship referred to yesterday.
Yes.
Which we've looked up overnight, and 3 contemporaneous documents, which I'll come to as and when necessary. Now, we had reached, in the survey of the authorities, the decision of the Supreme Court in Plevin. And I just wanted briefly to mention 2 other authorities which my learned friend referred to yesterday. The first is Samuel and Wadlow, which you'll find at Authorities B, tab 26. And I think we can go straight to page 492.
Yeah. I'm not sure that you get a great deal out of this case, actually, because it's all rather tentative.
No, we don't get much out of it, my lord, because it's obiter, A, it's obiter, and B, it's in the realms of undue influence, with which we're not concerned.
Yes.
But just to pick up a couple of points of what Lord Justice Toulson, as he then will says, para 39, he says it may not be easy to determine whether the parties intended the contract should continue or be discharged, since the distinction is one of legal theory which might have little commercial meaning for the parties. He says in relation to the present case, he comments on that, and then he says from a practical viewpoint, it is a distinction without a difference. Now, I'm sure that was right in relation to the case before the Court of Appeal there. It may well not be right in relation to our case, because of course in our case, the distinction has a lot of commercial meaning, and it is a distinction with a very big difference.
Yes.
And the other thing one would get, I seek to get out of paras 39 and 40, is that, and I'll come back to this point I think a little bit later on, but in the real world, people vary their contracts. I'm not talking about instructions under construction contracts, but contracts of all kinds are varied by agreement every day.
Yeah.
And it never occurs to anyone to get out Morris and Barron and say, oh dear, you're rescinding or you're entering into a new contract. That's just isn't the way that commercial life operates.
Well, because it doesn't matter.
Because it doesn't matter, exactly.
But when it does matter,
well,
when it does matter, you may need to perform what Lord Justice Toulson calls a legal analysis.
Yes, I'll get to that point, my lord. The other point which really sort of which really links to the submission I've just made is at the bottom of the same page, paras 45 and 46.
Yeah.
Lord Justice Toulson says it's a sterile question, but then this, and this is in my submission of some assistance, the principle in Morris was brought into existence to deal with the technical problems produced by the statute of frauds and analogous legislation. The less that it is brought into other parts of the law to deal with problems of a different nature which do not require a formalistic approach, the better.
But that begs the question too.
Yeah.
Do we require a formalistic approach where the question is, does particular legislation apply?
Well, my lord, can I just develop that point in this sense, that there was some discussion yesterday of the concept of fundamental variation, and it was effectively submitted or discussed to the effect, well, if you've got a fundamental variation, then the existing contract goes. If you've got a non-fundamental variation, it doesn't. And in my submission, there is no such thing as a fundamental variation, in the sense that the court says to the parties, you can vary your contract up to this point, but you can't vary it any further. If the parties agree to vary their contract, the court will give effect to that variation, subject, as Lord Justice Toulson points out, to what I would call the Section 4 type cases, such as Morris and Barron, where the statute forbids effect being given to the intention or agreement of the parties. And in relation to my Lord's question, in our submission, HMRC have not identified any case outside the Section 4 type situation, whereas Lord Devlin pointed out in Shoecare, the intention of the parties, the agreement of the parties, is being frustrated by formal requirements. They have not identified any case in which the courts have held that a quotes variation amounts to a rescission or a new contract. The point simply doesn't arise for the reasons that I have mentioned in the ordinary course of things.
Well, that's probably because it doesn't often matter.
But my lady, with great respect, that is in danger of looking at things through the wrong end of the telescope, because let's in our case, let's for a moment ignore the taxation situation entirely and ask ourselves the question, if the parties had entered into these arrangements as they did, would any objective observer have been seeking to persuade them that there was a rescission or a new contract? My lady's point simply wouldn't arise. And as I'll go on to submit in relation to the section, the parties have agreed, HMRC have conceded, that this question has to be decided by the law of contract. And indeed, in my submission, the only case really which HMRC can point to outside what I'm calling the Section 4 type cases is the Shell decision, which is on the next tab. You were taken to that. I'm not going to weary you with the facts, but I make 5 points about Shell. First of all, it's not binding on this court or the Upper Tribunal. Secondly, the relevant passage is obiter. Thirdly, it obviously turns on its own facts. Fourthly, it predates Lord Sumption's guidance in Plevin as to the correct approach. And fifthly, for the reasons explained by the Upper Tribunal in their judgment at para 104, it is wrongly decided.
Yes.
So, turning then, after that tour through the authorities, turning then to the decision, the judgment, that's in the core tab 9. At page 220.
Yes.
Now, when I get on to the facts in a moment. I'm just going to remind the court of the issues which they were considering, but I take it from comments made yesterday that the court's well familiar with the judgment in any event. But our submission is that the Upper Tribunal was directing itself quite correctly as to the law. At paragraph 90, they cite Viscount Haldane's famous statement, which we now know, per Lord Sumption, is a correct statement of the law. Then at paragraph 96, last two sentences, it seems to us that the case, that's Morris, is authority for the proposition that the difference between rescission and variation is dependent on the intention of the parties. We would say correct. In the absence of other evidence, the fact that changes go to the root or inconsistent might lead to an inference that the parties intended to rescind the contract, but the question remains one of intention. Correct in our submission. Then they deal with the cases we've just looked at, Samuel and Shell.
Yes.
And then para 105, in turn determining whether the parties intended the change orders to rescind, we accept they agree with HMRC correctly that intention is to be ascertained objectively, that's right. Para 106, that's their answer to the question. So they've applied a test based on the parties' intentions. They intended to vary, not rescind. And they make the point which I've just made, that this is a long way from Samuel and Wardley, where the parties are not concerned with this. Viewed objectively, the parties to the Golden Contract clearly intended that contract to preserve the entitlement for someone to claim EZAs on construction expenditure.
Where does that come from, that intention?
Well, is it convenient if I deal with the facts?
All right.
I'll come back to the facts in a moment, if I may. The change orders were similarly intended to result in a building being constructed that was somewhat different from those provided for, but for EZAs still to be available. Now, just while we're on that point, may I respectfully adopt the point my lady put yesterday to my own friend, the ballpark point. Clearly, these parties cannot procure the result that HMRC give them tax relief. What, however, they can do objectively is to so make their arrangements as to give themselves, as it were, every sporting chance of that result. Ultimately, the decision obviously is for HMRC, but that is the aim. Now, Milady expressed some reservation about the last sentence of paragraph 106, and it concerns me to see that sentence begins with the words "Mr. Williamson was correct to submit." But leaving aside my inglorious role in the paragraph, in my submission, what the Upper Tribunal, the word desire is perhaps slightly infelicitous, save only, of course, that is the word used by Viscount Haldane as we see at paragraph 90. But in my submission, what they're saying in the context of everything else they're saying is that objectively it is the intention of the parties to keep the contract on foot and not to rescind. Then at 107, they deal with Mr. Cosmin's objection. Well, you're giving too much weight to subjectivity. And here are I was going to come to this under the heading of the facts, but here are the facts. The developer and contractor were under common control. The Golden Contract was, as a matter of fact, entered into specifically to ensure that EZAs could be claimed. The expectation that the EZAs would continue was not simply an unexpressed subjective wish. On the contrary, the desired tax benefits informed the willingness of the developer and the contractor, etc. So the aim, object, genesis of the change orders was, as they say in the last sentence, that the EZAs should continue to apply. But then, at paragraph 108...
Where does that come from? Where does it come? I mean, it's an inference which the Upper Tribunal draw. We haven't seen any finding that was an expressed intention, have we? We haven't seen a finding that was the expressed intention at the time of the change order. All we have is the change order,
Yes.
which purports to be given under clause 12 in relation to works option 1, not a variation, but an implementation of clause 12. So it doesn't purport to vary the contract, it purports to give effect to it. But works option 1 had already been selected by the developer under change order 1. So the contractor was obliged to build whatever it was under change order 1. So where do we get the Upper Tribunal's conclusion from? I mean, I can see that now that the LLPs are in dispute with HMRC over whether they're entitled to EZAs. They obviously want the EZAs. That's then it's Pikestaff. But contemporaneously, where is the evidence on which the
I'm sorry to keep ducking the question. Can I come to that when I deal with the facts? But I just wanted to...
Sorry, I thought you were telling us that these were the facts.
Yes, in my excitement, I lightened upon that paragraph, but I'm going to come back to it on the facts. But what the point, just so I don't lose this point, the Upper Tribunal then effectively say, well, there's been an acceptance on behalf of the LLPs by Ms. Shaw that there may be situations where the apparent common intention is so inconsistent with the ways they actually acted to call the intention into question. So again, I would submit that is a perfectly correct approach to the law, and we'll come back to this, but they then go through what are said to be the fundamental differences between the original bargain and the varied bargain, and they say, well, as a matter of fact, that doesn't add up to very much. See para 109.
But why is that a legitimate exercise? Because they first of all come to the conclusion that there was an objective intention to vary, not to rescind, and then they look at the objections to that and say, well, none of those actually amount to a hill of beans. But surely what they should have been doing is looking objectively at all of the evidence together, including the differences, to see whether they could ascertain the intention from that evidence, and they put it the wrong way round.
Well, maybe I'm not. With respect, I'm not sure it really makes a large amount of difference. They've said here is the common intention of the parties. But they then effectively said, well, if we're wrong about that, and we have to consider this question by reference to the extent of the differences are not substantial.
Where do they say if we're wrong about that?
Well, they are dealing here with Mr. Cosmin's submission, as we see at the beginning of paragraph 108, that there are such differences between the change orders and the original contract as to invoke the Morris and Barron principles.
See, as I read it, they've made up that they've got the result that they've reached first, and then they're looking at Mr. Cosmin's submissions to see whether or not they should derogate from that result. And that is an illegitimate exercise. What they should have done is looked at all of the facts, including Mr. Cosmin's submissions about the differences, and then come up with the result.
Well,
you say it may not make a difference, but legally it could.
Well, Major, there are two rival contentions as to how Morris and Barron operates in circumstances such as this. One, which is our primary case, which is to say it's as per Plavin, in which case you're concerned with the common intention of the parties. Secondly, if for some reason we're wrong about that, then one considers, is there a fundamental inconsistency between the varied and the original contract? And that's exactly the question the Upper Tribunal are considering.
But they're not two. They're not separate questions. Even if one's in Plavin territory, and let's assume for the moment that you're right, the way that you ascertain the common intention of the parties for these purposes is to look at the differences as well as the circumstances surrounding the so-called variation.
Well, lady, I'm afraid we may have to agree to differ on that point. In my submission, that isn't the right approach. The right approach is to apply what Viscount Haldane says, which is recited as paragraph 90 of the judgment. Even if there is, in his words, sweeping alteration, that doesn't, to use your ladyship's expression, add up to a row of beans, or unless that is accompanied by an intention for a complete extension of the first contract.
No, we seem to have lost Lord Justice Newey.
Ah.
Quite sure what's happened there.
No. Yes. I'll try and get Alan.
Hmm? Yeah, he's just gone. Yes, he only disappeared from the screen a couple of seconds ago, so he won't have missed anything so far.
Well, he's probably watching it on the live stream.
Well, that's possible.
He said he could hear better on the live stream yesterday but the problem is the delay.
Do we know what's happened?
We've just lost him. Alan is coming down, so we set it.
Oh, right. Could you get hold of his clerk and see if she can get him on the phone or something? The wonders of modern technology.
Yes.
I think it may take 10 to 15 minutes to resolve, Mr. Williamson, but we're making inquiries to see if we can get a message to Lord Justice Newey.
Right.
And
Well, I hope the court won't regard us as a discourtesy then if I sit down for a moment.
Do you want to rise? Yeah. I think we'll rise until Lord Justice Newey comes back again, rather than keep everybody sitting in silence.
No, go ahead. I agree. Yeah. Yeah.
So we had
Yeah.
the visual, but not the sound. The sound is my own every time I shut it.